Unit 3 SCOTUS cases. It's only going to be the required ones, not the non-required ones. I'm going to start off with Angle v. Vitale, 1962, where the summary of it basically was New York public schools required students to recite a short voluntary prayer each morning. And even though the prayer was non-denominational, parents challenged it as a violation of the Establishment Clause, and the Supreme Court ruled that any state-sponsored religious activity in public schools is unconstitutional. It reinforced the separation of church and state, and the holding was schools cannot create, sponsor, or endorse religious activities. And even though it was a voluntary prayer, it still violates the Establishment Clause. Students also retain their constitutional protections at school. It also reinforced the principle of government neutrality in religion, not favoring one and not, shitting on one. It also set a precedent for future cases limiting religion in public institutions. The next one's going to be Wisconsin v. Yoder. Summary on it would be the Amish community wanted to withdraw their children from public schools after the 8th grade, to focus on farm work and religious life, whatever they had going on. And the Supreme Court ruled that forcing attendance beyond the 8th grade violated the free exercise clause of the First Amendment, as the parents, religious rights outweighed the state's interest in education. The Amish community proved that, they have been doing this for a very long time and that they can support themselves and all these other things, that they do not need the education past the 8th grade. The holding of this was parents have the right to direct their children's religious upbringing. Compelling attendance beyond the 8th grade violates religious freedoms, balanced state interests with individuals' religious rights. It also protected minority religious practices against general laws, and it set a precedent for cases involving religion versus state regulations. The next one is going to be Tinker v. Des. I still don't know how to say it. Tinker v. Des Moines. That's how I say it. Stupid. Probably isn't how you pronounce it. But the summary on this would be, students, the Tinker twins. I'm going to get into that after I finish this. But the Tinker twins, they wore black armbands to protest the Vietnam War that was going on, and they were ultimately suspended. The Supreme Court ruled that the students, do not shed their constitutional rights at the schoolhouse gate, end quote. Symbolic speech, such as wearing armbands, is protected as long as it doesn't cause substantial disruption to the school's operations. As long as they're not disrupting, as long as they're not, stopping things from the routine that goes on in the school, then it's fine. The holding, students have the right to symbolic speech in school. Schools cannot censor expression just because they disagree with the message. Restrictions are allowed only if the speech substantially disrupts learning or school activities, and it reinforced the First Amendment protections for students. And it also set a precedent for nonverbal protest rights in schools. I saw a TikTok video, I might put it up after, where a guy was punched for having a banner or something, a poster supporting ICE, saying "I support ICE," and he was saying "I support ICE, I support ICE." He ended up getting punched. He was asking the teacher, or whoever it was, if it was okay to hold that message up, and the teacher, said it was okay. His right to protest in school, as long as he wasn't disrupting. The reason why I call them the Tinker Twins is if you've seen The Social Network, great movie by the way. The Winklevoss twins. I don't know how I put them, together or whatever, but it works for me. Tinker Twins, Winklevoss. That's how I put it. So when I think of the Winklevoss twins, or when I think of the Tinker Twins, I think of the Winklevosses, Social Network. That's how I view it. The next one is going to be Shank v. United States. I think they called him something different. I forgot what it was. Skank. There we go. Skank. The summary on this would be during World War I, Charles Shank distributed pamphlets, urging people to resist the draft. The Supreme Court ruled that free speech is not absolute, especially when it presents a clear and present danger to national security. The case established a legal standard for when speech can be restricted during times of war or public crisis. The holding was speech that poses a clear and present danger to public safety or national security isn't protected. Government can limit expression if it creates an immediate threat. Introduced the clear and present danger test for limiting speech. Context and timing are critical in evaluating free expression. And it also set the precedent for balancing individual liberties and public order. The next one is going to be the New York Times versus U.S., 1971. The key principle of this one would be the First Amendment, freedom of the press, right? Case summary on this would be the Nixon administration, attempted to prevent the New York Times from publishing the classified Pentagon Papers. And this is very interesting regarding the Vietnam War. The Supreme Court ruled that prior restraint, government censorship before publication is almost always unconstitutional, even when national security is cited. It strengthened the press's role as a government watchdog, you could say. The holding on this was the government can't prevent publication in advance except in extremely rare circumstances. The press enjoys strong protections under the First Amendment. National security does not automatically justify censorship, established a heavy presumption against prior restraint, reinforced the press as a check on government power. If I were to see something on the test where it talks about national security, I would assume automatically it's talking about New York Times versus the United States, automatically. So we're going to skip over these. We're going to McDonald v. Chicago. This is one of my favorite ones, Mr. Majewski, the person that has caused this suffering for me and other people, has a saying, or had like a little rhyme thing. It was like, old MacDonald had a gun, bang, 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 bang. You think of this old man, where, let me go to the case summary. Challenged Chicago's handgun ban. The Supreme Court ruled that the Second Amendment right to keep and bear arms applies to the states through the 14th Amendment's Due Process Clause. It clarified the scope of gun rights after D.C. v. Heller, which was a case in 2008, ensuring that individuals' rights to self-defense cannot be infringed by state laws. The holding was that the right to keep and bear arms for self-defense applies to the states. The 14th Amendment incorporates the Second Amendment, strengthened individual gun rights nationwide. States cannot infringe on fundamental self-defense rights either. And it also set a precedent for incorporation of constitutional rights to the states. Yeah. And then we're going next to Gideon v. Wainwright. The key principle is going to be the Sixth Amendment, right to counsel. Case summary is going to be that Gideon was charged with a felony, but he couldn't afford a lawyer. He represented himself and was convicted. The Supreme Court ruled that the right to an attorney is fundamental, and it must be provided by the state for defendants who can't afford one. It incorporated the Sixth Amendment's guarantee of counsel to the states via the 14th Amendment. The holding was that all criminal defendants are entitled to legal representation regardless of income, and that states must provide counsel for indigent defendants charged with serious crimes. It also demonstrated the incorporation of the Sixth Amendment through the 14th Amendment, and it reinforced the principle of fair trials and equal protection under the law. It also established a lasting precedent for access to justice. So, thank you, Gideon. Roe v. Wade. Funny story on this was that a girl in class was like, "What is Roe v. Wade?" And I don't know. I just thought that was kind of funny. Like, I thought everyone kind of knew Roe v. Wade. But the key principle is going to be the 14th Amendment Due Process Clause, implied rights to privacy. and the 14th Amendment. The case summary would be that it challenged a Texas law that banned most abortions, and the Supreme Court held that a woman's right to choose an abortion falls under the right to privacy, right? It was implied by the Constitution and incorporated through the 14th Amendment, and the decision limited state interference during early pregnancy and reinforced personal autonomy in medical decisions. The holding was that it protects a woman's right to choose an abortion under the right to privacy. Right to privacy is implied by the Constitution. State regulations cannot unduly interfere with early pregnancy decisions. It reinforced incorporation of individual rights via the 14th Amendment, and it also set a precedent for privacy and personal autonomy. Moving on to Brown v. Board of Education, the key principle is the 14th Amendment, Equal Protection Clause, and the case summary is that the landmark case challenged racial segregation in public schools. The Supreme Court unanimously ruled that segregated schools are inherently unequal, violating the Equal Protection Clause of the 14th Amendment. It overturned the separate but equal standard established in Plessy v. Ferguson, which was a case in 1896, and it also became a major catalyst, you could say, for the civil rights movement. Holding was that racial segregation in public schools is unconstitutional, and it reversed the separate but equal doctrine, affirming equality under the law. I'm so tired. It also ensured that all students have equal access to quality education regardless of their race. It strengthened the 14th Amendment Equal Protection Clause, and it set a legal foundation for desegregation and the civil rights reforms happening nationwide. So tomorrow's video is going to have these, and that's about it. And I'm going to be talking about how we can compare and contrast the cases as well for the FRQ. Yeah, so that's it.